This is the second YouTube video on the Sidumo case. Mr. Sidumo had been employed by Rustenburg Platinum Mines as a constable and went up in the ranks and eventually found himself employed conducting search procedures at the Waterval redressing unit. And he was called to a disciplinary hearing pursuant to 24 searches that were conducted, only one of which was conducted in accordance with the search procedures. Of the 24 procedures, eight were not conducted at all, and 15 did not conform to the search procedures. Now, the whole significance of these search procedures was to ensure that employees did not leave the premises of the mines with any of the precious metals or materials that remained the property of the mines, because evidence showed that the mines continued to suffer heavy loss as a result of employees pilfering precious metals and materials from the mines. So he was called to a disciplinary hearing, and the chairperson found that, notwithstanding that Mr. Sidumo had worked for the mines for 15 years and had a clean disciplinary record, that due to the nature of the offence, that it was sufficiently serious for Mr. Sidumo to be dismissed. As a result of which, Mr. Sidumo went to the CCMA, lodged a complaint about unfair dismissal, and he successfully challenged his dismissal. Although the arbitrator at the CCMA agreed with the chairperson of the disciplinary hearing that his dismissal was fair, the arbitrator found that the sanction of dismissal was not sufficiently progressive, and that as a result a more progressive sanction should have been imposed, and thus the arbitrator ordered that Mr. Sidumo be reinstated and be given 3 months compensation as well as a written warning. The mines obviously were dissatisfied with the arbitrator's finding at the CCMA and took the matter on review to the Labour Court, and they were unsuccessful in the Labour Court, where the matter was dismissed, and they then took it on appeal to the Labour Appeal Court, which also dismissed the matter. It is in the Labour Court where the court considered the matter against, or the review, with reference to the Carphone versus Marcus case, which will become extremely relevant for our purposes. It's a 1999 LAC case where it sets the standard of judicial review on the following basis: is there a rational, objective basis justifying the decision, the connection made by the arbitrator and the evidence before the arbitrator? So you need to establish that nexus. Is there that link that exists? And if that link is established, then there's no basis on which the court can interfere with the award. And it's for that reason that the Labour Court found, with reference to Carphone versus Marcus, that there was no basis upon which it should interfere with the decision of the Commissioner, because it was justified. In the Supreme Court of Appeal, however, the mines succeeded, because the Supreme Court of Appeal found that, firstly, it was within the discretion of the employer to elect the appropriate sanction, and in this regard it was dismissal. And they said in this regard the Commissioner should have deferred or paid deference to the employer. And for authority, the SCA referred to the Nampak Corrugated versus Wadeville, or at least Nampak Corrugated Wadeville versus Causa, a 1999 LAC decision, as well as the County Fair Foods versus CCMA, also a 1999 Labour Appeal Court decision. And the SCA said commissioners must approach their functions with caution. They must take account of the employer's discretion to impose an appropriate sanction, and they must defer. In other words, they must not lightly interfere with that discretion. And based on what's known as a textual, conceptual, and institutional approach, the SCA went on to say that item 7B4 of the Code of Good Practice, that's of the Labour Relations Act, requires commissioners to consider whether the dismissal was an appropriate sanction as opposed to the appropriate sanction. So they made a distinction between and the. And what's more significant in this regard is that the CCMA also found, with reference to sections 145 and 1581G of the Labour Relations Act and Kefan versus Marcus, that administrative justice provisions of the Constitution, namely section 33, as read with item 23(2)(b) of item 6 of Schedule 6 of the Constitution, that all those provisions extended the scope of review. In other words, because what the CCMA Commissioner did constituted administrative action, it meant that administrative action had to be justified in respect of the reasons given for it. So this introduced the rationality test, so to speak. And in support of their finding in this regard, they referred to Shoprite Checkers versus Ramdor, a 2001 LAC decision. And the LAC in the Ramdor case, and the SCA also agreed that it was not necessary to apply Padja or to decide whether or not Padja applied, because they were applying the provisions of item 23(2)(b) of Schedule 6 as read with section 33, because at that point in time Padja had not yet been enacted. This is the end of video clip 2.